Please subscribe to the channel to watch the latest videos.
New York judge fines Trump $5,000 for violation of gag order. New York, a New York judge Friday issued a $5,000 fine against Donald Trump because the former president violated a gag order by failing to remove an item about a court staff member from his website. New York Supreme Court Judge Arthur Engoron, who issued the gag order after Trump's post on his social media site October 3, wrote in a two-page decision regarding the fine that Trump was responsible for the contents of his website. Trump was warned about discussing members of the judge's staff, and posts such as the one that identified a court staff member could have serious safety consequences, Engoron wrote. In the current overheated climate, incendiary truths can, and in some cases already have, led to serious physical harm, and worse, Engoron wrote. Engoron said that any future violation of the gag order could result in steeper financial penalties, holding Donald Trump in contempt of court, and possibly imprisoning him. The $5,000 fine, which the judge called nominal, is due within 10 days and must be given to the New York Lawyers Fund for Client Protection, which assists clients whose legal matters have been mishandled by their attorneys. The judge acknowledged the assertion by Trump's defense that the failure to remove the item was unintentional. The item, posted October 3 on Trump's Truth Social site, also was emailed to media recipients and archived on donaldjtrump.com, where it remained until recently, when a media website published an item about it. The post had been removed from Truth Social the same day the gag order was imposed. Trump lawyer Christopher Kise said in court Friday that his client has not made any statements of any kind about court staff, has abided by the order completely, but it appears no one also took down the link that's in the campaign website in the back pages. Kise said Trump had no intention to evade or circumvent or ignore the order. Trump is being sued for $250 million by New York Attorney General Letitia James for allegedly defrauding banks and insurance companies by misleading them in deals with the Trump Organization about the extent of his net worth. Trump and his lawyers have denied any wrongdoing. He does not face prison time in the civil trial. The judge has already found in a summary judgment decision that Trump and his company were liable for committing fraud and has ordered the dissolution of Trump entities in New York under a receivership. That decision is under appeal. The trial is being held to determine if specific illegal acts were employed to advance the fraud. Under the receivership that has already been ordered, Trump could lose control of his New York properties, including Trump Tower on Fifth Avenue. Trump has used courthouse appearances as opportunities to campaign. Outside the courtroom, he has gone on tirades against the judge, James, and others. In Washington, D.C., on Friday, U.S. District Judge Tanya S. Chutkan issued a week-long stay of a separate gag order that she issued to Trump on Monday. Chutkan, who is overseeing his D.C. criminal case for conspiring to obstruct the results of the 2020 election, imposed the gag order after expressing concerns about potential harassment of individuals involved in the case, including her court staff, because of Trump's rhetoric. Trump lawyers have filed their intent to appeal, arguing the 2024 presidential candidate's First Amendment freedoms will be violated by the restriction. Trump faces separate criminal charges in Georgia related to alleged attempts to overturn the results of the 2020 election, in Florida for accusations of hoarding sensitive government documents at his residence and private club, and in New York for allegedly falsifying business records related to a hush money payment made in 2016. He has pleaded not guilty to all charges. Rachel Weiner in Washington contributed to this report. What to know about the gag order a D.C. judge placed on Donald Trump? On Tuesday, hours after Judge Chutkan posted the written order on the court docket, Donald Trump and his lawyers filed a notice of appeal. U.S. District Judge Tanya S. Chutkan has issued a limited gag order against Donald Trump that prohibits the former president from disparaging prosecutors, witnesses, and court personnel involved in his upcoming election obstruction trial in federal court in Washington, D.C. Trump, who says the order violates his First Amendment rights as he is running for president, has filed his intent to appeal. On Friday, Chutkan paused the gag order for a week while she considers Trump's request to put it on hold during the entire appeals process. Here's what to know about the gag order imposed on Trump and gag orders in general. What is a gag order? A gag order is issued by a judge and generally prohibits someone from talking about a legal case or aspects of one. Defense lawyers, as opposed to the defendants themselves, are often the recipients of gag orders, according to Anna G. Kaminsky, a law professor at New York Law School. It would usually be an attorney, because defendants typically are not doing the talking, because everything they say can be used against them in a court of law, Kaminsky said. Who does Judge Chutkan's order apply to? This gag order applies to Trump and his attorneys. Chutkan said it also prohibits them from directing anyone to make statements that would violate the gag order. This gag order also applies to the prosecutors on the case. What does it mean that Chutkan gave Trump a limited gag order? A gag order would prohibit Trump from talking about the case at all. A limited gag order means Trump cannot make certain types of public statements about parts of the case. In this instance, Chutkan said that Trump must stop disparaging prosecutors, witnesses, and court personnel involved in his upcoming D.C. trial on charges of conspiring to obstruct the results of the 2020 election, which is scheduled to begin in March. But Chutkan said in her order that she would not prohibit Trump from continuing to make disparaging comments about President Biden, his likely rival in the 2024 election. Trump can also claim that the case against him is politically motivated, as long as he doesn't denigrate individual prosecutors, the order said. How could an appeal affect the trial? Soon after Chutkan issued her written ruling, Trump's legal team filed a notice saying he will appeal the decision. Some legal experts have said an appeals court or Supreme Court fight over the gag issue could push the D.C. trial past its planned March start date. How long will the order be on hold? Trump asked Chutkan to pause the ruling from going into effect until the appeals process plays out. Chutkan said that she would pause the order from going into effect, for now. She asked prosecutors to respond to Trump's request before she rules whether she will stop it from going into effect until the appeals court rules. What does the order say about former Vice President Mike Pence? Chutkan specifically mentioned Pence, a witness in the case who is also seeking the 2024 GOP presidential nomination, in her order. She said Trump is free to criticize his former vice president's campaign platforms and policies. But, Chutkan noted from the bench Monday, the gag order would prohibit Trump from talking about Pence's role in the election obstruction case. Why would a judge issue a gag order? Judges most commonly issue gag orders when they fear someone's speech could taint the jury pool or intimidate witnesses. Judges are allowed to decide how to run a courtroom, and that includes how a defendant's behavior or a lawyer's behavior could affect the court, the running of the court, or court staff and potential jurors, Kaminsky said. In Trump's case, Chutkan said the former president has made statements attacking individuals involved in the judicial process, including potential witnesses, prosecutors, and court staff. As Chutkan put it in her order, in order to safeguard the integrity of these proceedings, it is necessary to impose certain restrictions on public statements by interested parties. What happens if Trump violates the gag order? Judges typically impose sanctions when a defendant violates their orders. Those sanctions can range from an admonishment to financial penalties to jail time. Chutkan did not specify what sanctions she would impose if Trump violates her gag order. But legal experts say it would be extremely unusual for a judge to jail a person as they are running for office. Has Trump been issued a gag order in any of the other cases against him? In early October, the New York judge overseeing a civil trial over alleged business fraud committed by Trump and his company issued a gag order. The gag order prohibited Trump from making public comments about staff in the Manhattan courthouse. It came soon after Trump posted a photo of one of the judge's employees on social media, along with a critical message. A New York judge fined Trump $5,000 fine on October 20 because at least one copy of that message remained on the former president's website. Trump does not face a gag order in his other three indictments: a state election obstruction case in Georgia, a state indictment in New York related to hush money payments in the 2016 election campaign, and a federal case in Florida involving alleged hoarding of classified documents and obstruction of government efforts to get them back. But because Justice Department Special Counsel Jack Smith is prosecuting both the D.C. and Florida cases, there are implications for Trump's conduct in the Florida case as well. It's also possible some witnesses in the D.C. case, such as retired General Mark A. Milley, the former chairman of the Joint Chiefs of Staff, could be called as witnesses in the documents case or the Georgia state case. As a witness in D.C., Milley is one of the people Trump cannot disparage, according to Chutkan's orders. What did Trump say after the D.C. gag was imposed? Campaigning in Iowa on October 16, Trump called the gag order so unconstitutional. He also hinted that he might escalate the conflict. "What they don't understand is I am willing to go to jail if that's what it takes for our country to win," he said. Some notable gag orders, and what happened when they were violated. One Dallas city official was sent to jail. A St. Louis lawyer was ordered to spend 100 hours doing presentations on respect for the law. Former President Donald Trump faces 2 partial gag orders barring him from making certain types of public statements related to his upcoming D.C. trial on federal charges of seeking to block President Biden's 2020 election victory, and to a New York civil fraud case about inflating property valuations. On Friday, he was ordered to pay $5,000 for violating the New York order by failing to remove a social media post about a court clerk from his website. That same day, he asked for the D.C. gag order to be put on hold while he appeals, and the judge said she would pause it temporarily. Here are some other examples from notable cases where gag orders were violated by defendants or others involved in the cases. Roger Stone, lying to Congress. Stone, a longtime Trump confidant, was indicted in Washington, D.C., in 2019 for lying to Congress and covering up his efforts to learn about hacked Democratic emails before the 2016 election. U.S. District Judge Amy Berman Jackson barred all parties in the case from making potentially prejudicial statements in public or interfering with the administration of justice at the courthouse. During pretrial proceedings, Stone posted on Instagram a photo of Jackson with an image that resembled rifle scope crosshairs next to her head. In response, Jackson expanded her gag order, banning Stone from speaking publicly about the investigation or case against him. When Stone continued posting vitriolic and profane messages about the case, the judge barred him from Instagram and other social media for the duration of his prosecution, citing his middle school behavior. Stone was convicted on all counts and sentenced to more than 3 years in prison. Trump commuted his sentence and pardoned him before leaving office. Prosecutor Marilyn Mosby, Keith Davis murder trial. A state judge in Maryland issued a gag order in the high-profile 2022 trial of Keith Davis Jr., a Baltimore man who had been tried 4 times previously in the 2015 murder of a racetrack security guard. Each trial ended in a hung jury or a guilty verdict being overturned. Before the 5th trial, state's attorney Marilyn Mosby had asked for a gag order because of intense public scrutiny of the case. Then she replied on Instagram to a woman who criticized the prosecution with the comment, "You really shouldn't believe everything you read." Circuit Judge John Nugent ruled that Mosby's post was a willful violation of this court's gag order and fined her $1,500. The judge said Mosby could avoid the fine by abiding by a stricter gag order, which Mosby did. Her successor as state's attorney eventually dismissed the murder charge against Davis. Lawyer Albert Watkins, trial of former Missouri Governor Eric Greitens. Watkins represented a witness in the criminal trial of former Missouri Governor Eric Greitens. His client was the ex-husband of the woman whom Greitens had an affair with, and then allegedly assaulted and blackmailed. St. Louis Circuit Court Judge Rex Burleson imposed a gag order in the case, but Watkins held a news conference outside the courthouse less than 2 weeks later. Watkins said he didn't know about the order. He then apologized to the judge, who ordered Watkins to make 100 hours of presentations to outside groups on the importance of complying with court orders and how not doing so can harm the justice system. Interesting side note, Watkins would later represent QAnon shaman Jacob Chansley, convicted of obstructing Congress during the January 6, 2021 Capitol riot. Dallas City Council member Donald Hill, bribery trial. Hill, who served as mayor pro tem when the mayor was unavailable, was charged with extorting bribes from potential city contractors. The judge imposed a gag order on both sides 10 days before the 2009 federal trial. 6 days later, Hill gave a television interview in which he said people have shown that during the Bush administration that Democrats were targeted, and other similar statements the judge thought could influence jurors. Hill was sentenced to 30 days in jail for contempt of court. His lawyer received a $5,000 fine and a 120-day suspension of his license. Hill also was convicted on the bribery and conspiracy charges. His 30-day sentence for violating the gag order was added to his 18-year prison sentence. Oklahoma County District Attorney Bob Macy, Oklahoma City bombing. Macy was prosecuting Terry Nichols on state charges of conspiring with Timothy McVeigh to carry out the April 19, 1995, truck bombing of the Alfred P. Murrah Federal Building. The bombing killed 168 people, the deadliest terrorist attack on U.S. soil until September 11, 2001. A judge barred attorneys from publicly discussing the case ahead of Nichols's trial in 2000. The defense moved successfully to disqualify Macy, saying he had an emotional personal stake in the outcome of this case and violated the order during an interview with CBS News on the 5th anniversary of the attacks, in which he said, "I certainly feel that death would be the appropriate punishment for killing 19 babies." Macy was replaced by assistant prosecutors in his office, and Nichols was convicted. CNN, Manuel Antonio Noriega corruption trial. CNN violated a judge's gag order in the corruption trial of the deposed Panamanian leader, airing leaked Justice Department recordings of Noriega's telephone calls from a Miami area prison about two potential witnesses. Convicted of contempt of court, CNN apologized 4 years later and paid the government $85,000 to cover the cost of the contempt prosecution in lieu of being hit with a larger fine. Sam Bankman-Fried, pre-gag violation in crypto case. A judge can punish people for violating court rules by attacking witnesses or prejudicing potential jurors even without a gag order, as seen in the case of former billionaire crypto trader and FTX founder Sam Bankman-Fried. Weeks before his trial this month for allegedly stealing billions of dollars from investors, Bankman-Fried was sent to jail in August after giving the New York Times the private writings of a key government witness, Caroline Ellison, his former employee and girlfriend. U.S. District Judge Louis A. Kaplan ruled that the disclosures were tantamount to witness tampering and ordered Bankman-Fried jailed pending trial, finding that he violated his release conditions and revoking his $250 million bail. The judge then entered a gag order in the case, which is currently on trial. Kaplan is also overseeing the civil defamation lawsuit against Trump brought by writer E. Jean Carroll, which is scheduled for trial in January. Split screen, Biden speaks to the world, Republicans can't pick a speaker. The contrast between the two political parties was especially striking as Biden responded to the Israel-Gaza war and House Republicans failed to pick a leader. Rarely is the contrast between the leadership of the two political parties as clear as it has been in recent days. President Biden has been steadfast in responding to the vicious attacks against Israeli citizens by Hamas terrorists. Republicans in the House have been so consumed by internal differences that they have left Congress immobilized when action is demanded. The split-screen projections have reinforced perceptions that Republicans are unable or unwilling to govern. Too many Republicans in the House operate in a bubble constructed of false claims about the 2020 election and conspiracy theories about a potpourri of other topics, a worldview shaped by a diet of Fox News and the erratic and at times dangerous rhetoric of former President Donald Trump. Their legislative goals, to the extent they prioritize them, are mostly unrealistic in a Congress as narrowly divided as this one. Biden does not have the luxury of dealing with such a world of his own creation. He is the leader of the free world and events intercede, as they have done in the past 2 weeks. Whether his handling of the Israel-Gaza war is changing perceptions of a president with low approval ratings is questionable. It has, however, provided a case study in the value of experience, expertise, and preparation when the unexpected happens. Republicans have now effectively shut down the legislative branch of government for 2 weeks because they cannot unify around anyone to become House Speaker. After dumping former Speaker Kevin McCarthy, Republican, California, they designated Majority Leader Steve Scalise, Republican, Louisiana, to be the Speaker and then allowed him to be so undermined that he withdrew his own nomination without a floor vote. Representative Jim Jordan, Republican, Ohio, raised his hand and then suffered through 3 losing ballots on the House floor, falling further behind the necessary votes with each ballot. House Republicans then told Jordan on Friday that his time was up and broke for the weekend, keeping Congress in paralysis. Chaos hardly describes the scene on Capitol Hill. They are damaging not only themselves as a party but also faith in the United States as a stable democracy. As Republicans remained mired in their infighting, Biden tried to project something different. His week was one that few presidents have experienced. His days included a sudden trip to the war zone that is Israel today, progress and then setbacks in efforts to get humanitarian aid flowing to civilians in Gaza, and a full-throated embrace of Israel's right to defend itself while in Tel Aviv, coupled with frank words, publicly and privately, about the difficult choices Israel must make militarily. Finally came his Oval Office address on Thursday evening, in which he coupled a request for $61 billion in additional aid for Ukraine and $14 billion in assistance for Israel with a restatement of his belief that the United States must lead in the face of these challenges. American leadership is what holds the world together, he said. American alliances are what keep us, America, safe. American values are what make us a partner that other nations want to work with. It now falls to Congress, still without a House Speaker, to act on whether to approve the foreign aid. Biden has come in for considerable criticism during his nearly 3 years in office. His detractors say he is old, weak and uninspiring, and worse. The messy withdrawal from Afghanistan in 2021 left a permanent scar on his foreign policy record. Some have blamed him for the Hamas attacks, claiming he has not been tough enough with Iran. He will have to fight to win re-election next year in a race likely to pit him against Trump in a rematch of 2020. Some presidents have found themselves ill-prepared when international crises erupted. Woodrow Wilson hoped to be a domestic policy-oriented president, and then World War I broke out. George W. Bush was an inexperienced leader when terrorists attacked the United States on September 11, 2001. Those who know Biden well say his response both to Russia's invasion of Ukraine and Hamas's horrific killing and hostage-taking in Israel reflect a lifetime of experience in foreign affairs and long-held views about the U.S. role in the world. They note that the conflicts represent a world that is familiar to him. He long has been oriented toward Europe and to America's traditional alliances there, and he has spent decades dealing with Israel and the Middle East. They're part of the infrastructure of global politics that have existed his entire life, said Ivo Daalder, former U.S. ambassador to NATO and now president of the Chicago Council on Global Affairs. He has a framework that clicks on and allows him to make the case he needs to make. Biden, who joined the Senate in 1973 and was a longtime member and eventually chairman of the Senate Foreign Relations Committee before becoming vice president in 2009, has lived through events, has met and known foreign leaders over decades, and has formed strong views about America's geopolitical role. He sees this moment as particularly momentous, an inflection point, as he said again on Thursday night, a time that has called on the United States once again to step up. In this country, public support for Israel is strong, perhaps stronger than it has been in years as a result of the carnage inflicted by Hamas. Support for continued assistance to Ukraine has slipped among Republicans, though most Republican leaders in Congress still back the course Biden has followed. Putting aid for both countries in the same package enhances the likelihood that Ukraine will get what administration officials believe it needs. On Ukraine and now Israel, Biden has earned praise from abroad and from many in the foreign policy community at home. On Ukraine, he took the unusual step of sharing U.S. intelligence to warn European allies and Ukrainian leaders that Russian President Vladimir Putin was preparing to launch a war against its neighbor. When that happened, Biden was able to rally a coalition that has provided the arms and other assistance that has allowed the Ukrainians to sustain their war effort. When Hamas attacked Israel on October 7, Biden responded by offering Israel the full support of the United States to defend itself, calling Hamas pure, unadulterated evil and then showing his commitment with his trip to Israel. Having done that, he made it possible to offer frank advice to Israelis and to warn their leaders to think carefully about the military steps they are preparing. When I was in Israel yesterday, Biden said on Thursday, I said that when America experienced the hell of 9/11, we felt enraged as well. While we sought and got justice, we made mistakes. So, I cautioned the government of Israel not to be blinded by rage. Whether Biden's predecessors would have moved as quickly and with as much determination is an open question. Still, difficult days lie ahead for Biden. The Ukrainians have not achieved the breakthrough with their counteroffensive that U.S. officials had hoped might take place. The $61 billion in new assistance, if approved by Congress, could give Ukraine the resources it needs to get through fighting in 2024. Russia has suffered massive losses, but Putin may be looking ahead, hoping that the 2024 election will deliver a Trump presidency and a backing away from Ukraine by the United States. Maintaining full support from European countries will require constant effort by U.S. officials. Even more danger exists in the Middle East. There Biden is not the master of events. Events will control him, and decisions by Israel and Hamas will shape those events. A full-scale ground war by Israel with the purpose of wiping out Hamas could risk massive civilian casualties in Gaza, which could undermine what international support Israel now enjoys. The biggest fear is that a war between Israel and Hamas becomes a regional conflict, with Hezbollah attacking from Lebanon, aided by Iran, and with Israel overstepping in its response, triggering an all-out conflict. Some analysts see those dangers as far greater today than they were a week ago. This is Biden's world and likely will be through next year's election. He has set his course and made clear his priorities. Republicans in the House, beholden to Trump, can't even elect a speaker after 2 weeks of trying, let alone agree on a workable strategy domestically or abroad. That contrast speaks volumes about the current state of politics in the United States. Haley threatens to overtake DeSantis as Trump alternative, sending sparks flying. Escalating frictions between the two candidates vying for a distant second behind Trump are playing out before voters on the campaign trail and behind closed doors with wealthy donors. Nikki Haley is increasingly threatening to supplant Ron DeSantis as the principal GOP presidential rival to Donald Trump, escalating frictions between the two candidates that are playing out before voters on the campaign trail and behind closed doors with wealthy donors. While DeSantis held an advantage over other non-Trump candidates for much of the year, his support has eroded and Haley's has climbed, according to interviews with voters, strategists, and a review of early state polling, putting them in a contentious battle for a distant second place. Their teams circled one another at a recent private donor summit in Dallas, where they charted their respective paths before potential financial backers, many of whom have been skeptical about the ability of either to beat the former president. In the past few days, in the midst of the war between Israel and Hamas, the two candidates have tussled over their contrasting positions, both past and present, on U.S. policy in the Middle East and how to help refugees fleeing war-torn regions. DeSantis courted voters Thursday in Haley's home state of South Carolina, where she is leading him in the polls, before they crossed paths Friday in Iowa, where the Florida governor is anchoring his candidacy and has built a much larger footprint. The intensifying competition was evident in Iowa, where some voters said they had moved to Haley from DeSantis, and the two appeared at a multi-candidate event. Both focused on foreign policy, avoiding direct shots at each other in their remarks. Haley's campaign on Friday released a video labeling him desperate for attacking her, and when asked by a voter about her stance on accepting refugees from the Middle East at a town hall in Pella on Saturday, she used the opportunity to criticize DeSantis. God bless Ron DeSantis, because he continues to try and bring up this refugee situation. He has said that I want to take Gazan refugees. I have never said that, Haley said. He can keep doing it, but that's what happens when a campaign starts to spiral out. For the first time since making a small expenditure against Haley in April, Never Back Down, a super PAC supporting the Florida governor, invested significant money on the airwaves in recent days opposing Haley, echoing comments DeSantis has made publicly. They spent nearly $1 million airing a new ad in Iowa, according to disclosures filed with the Federal Election Commission, highlighting DeSantis's opposition to allowing refugees from Gaza into the U.S. and suggesting that Haley would be open to that idea. The ad misconstrued Haley's remarks in a recent CNN interview, and her campaign underscored that she is opposed both to providing U.S. aid to Gaza and to sheltering Gaza refugees in the U.S. The back-and-forth between the two camps marked a combative new phase of the GOP race that has echoes of 2016, where Trump's lower polling rivals trained much of their fire on one another rather than on him, a strategy that ultimately helped Trump win the nomination. Both Haley and DeSantis, who has been more forcefully criticizing the former president in recent weeks, are trailing Trump by an average of between 40 and 50 points in the polls. But advisors to both candidates see a narrowing of the field as an essential element to toppling Trump. That consolidation could happen sooner rather than later, as other candidates such as former Vice President Mike Pence and Senator Tim Scott, Republican, South Carolina, are struggling. The challenges for lower-tier candidates have led some Republicans to envision a contest that eventually comes down to 3 finalists, a runaway favorite in Trump and 2 longer shots with sharply contrasting pitches. Haley rose to third in a Washington Post average of national polling from October, with 8% support to DeSantis's 14%. She's pulled into third in Iowa, where DeSantis's support is still noticeably stronger, and jumped ahead of DeSantis in recent surveys of New Hampshire and South Carolina. DeSantis operatives and allies acknowledge that Haley is having a moment, and some increasingly view her as the main threat to his efforts to consolidate voters looking for an alternative. But they also argue she appeals primarily to a smaller, anti-Trump segment of the Republican electorate that many candidates are fighting over, and that she can't win enough voters from the pro-Trump majority of the party to defeat Trump in a head-to-head. In a closed-door address to donors this month in Park City, Utah, at a conference organized by former House Speaker Paul D. Ryan and attended by Senator Mitt Romney of Utah, Haley addressed the potential financiers who do not want to see Trump win the nomination. She bluntly told them that sitting on the sidelines is not an option and suggested their reluctance to engage has been a critical factor in Trump's dominance. "You need to make a choice, and I hope you choose me," she told them, according to several people who described her remarks in the private session. At the meeting of GOP megadonors who are part of the American Opportunity Alliance in Dallas, where the teams of both DeSantis and Haley were invited to present their respective cases, DeSantis campaign advisors argued that consolidation of the field would help DeSantis but not Haley, partly because 90% of DeSantis's voters would migrate to Trump if he dropped out, according to several people familiar with the presentation, who like others spoke on the condition of anonymity to describe private comments. At that same gathering, Haley's team cited polls showing her ahead of DeSantis in New Hampshire and argued that she is closing in on him in Iowa. They also noted her cash advantage over DeSantis, who had about $5 million left for the primary and $1 million in debts on reports recently filed with the FEC, compared to her $9.1 million in cash reserves for the primary. Haley's advisors told the donors at the Dallas meeting that the GOP contest is a two-person race between one man and one woman, according to people familiar with the presentation. "We have to have a new generational leader, one that's going to understand that these threats are real and we need new solutions to do with it," Haley said on Friday in Iowa as she detailed the foreign policy experience she gained through her role as UN ambassador. "I'm the only one running for president that can tell you I have delivered on 100% of my promises. Everything I told the people in Florida I will do, I've accomplished," DeSantis said at the same event. Different paths to power. DeSantis, 45, and Haley, 51, both represent a new generation of leadership in the Republican Party, but they have charted different paths to power. Haley, a conservative former South Carolina governor who has long appealed to the foreign policy hawks as well as moderates in her party, even as she has embraced some polarizing positions, has campaigned on her ability to find consensus on difficult issues such as the handling of the Confederate flag in her state and abortion. DeSantis, by contrast, has relished his role as a bomb-throwing firebrand in Florida, continually running to Trump's right on many issues in his quest for the nomination. Both were once allies of Trump, who endorsed DeSantis in his first tough race for governor of Florida and chose Haley as his ambassador to the United Nations. Haley has a more complicated history with Trump, criticizing and opposing him when he ran in the 2016 GOP primary before joining his administration the following year. She later said she would not run against the former president, but ultimately decided to do so. During the first debate, which Trump skipped, Haley called Trump the most disliked politician in America, drawing some boos. "We can't win a general election that way," she added. Haley is now drawing the DeSantis camp's attention after flying under the radar for much of the race. She and her team have criticized DeSantis off and on throughout this year, faulting his efforts to punish Disney, for example, or suggesting that he is a Trump imitator in a fall campaign memo. Trump has branded both candidates with disparaging nicknames. In a sign of Haley's rising influence, he has gone after her more in recent weeks than he had before. As recently as July, a DeSantis campaign memo was more focused on Scott than Haley. At a Never Back Down briefing with donors just ahead of the first GOP debate, strategist Jeff Rowe said entrepreneur Vivek Ramaswamy could become a problem and that the super PAC was spreading opposition research on him. The DeSantis camp hopes growing scrutiny of Haley will take a toll. At the same time, they publicly reject the notion that Haley is threatening to eclipse DeSantis, insisting that they are merely drawing out key policy contrasts between the two candidates' records just as they have done with other candidates. Ron DeSantis will always stand up against dangerous ideas and in support of Israel, DeSantis campaign spokesman Andrew Romeo said in a statement Friday. That doesn't change the fact that this is a two-man race for the nomination. The DeSantis campaign and its allies are drawing attention to Haley's past statements on refugees, pointing to her initial support for resettlements as governor of South Carolina and her opposition in 2015 to Trump's proposed ban on Muslim immigrants. The attacks do not note her 2015 opposition to refugees from Syria and loyalty to Israel as UN ambassador. Nikki Haley has a history of weekly flip-flopping on critical issues, and so far, she has never had to defend her actions, said Kristen Davison, chief operating officer of Never Back Down. She's provided an opportunity with her own missteps to fully expose her record versus her rhetoric. She will not be able to survive that. The Haley campaign said the attacks from DeSantis and his allies were proof of her assent. Nikki has a long and strong record of taking on Hamas and standing up for Israel. Since announcing, DeSantis insisted it's a two-man race between him and Trump. As his fundraising and poll numbers plummet, he's lobbing false attacks at Nikki because he knows it's a two-person race, Nikki and Trump, her spokeswoman Olivia Perez-Cubas said in a statement. In Iowa on Friday, DeSantis spoke of the ties between Israel and Florida and touted his role in organizing flights out of the country. Haley highlighted her foreign policy experience, recalling telling Israeli Prime Minister Benjamin Netanyahu to finish them when speaking about the threat posed by Hamas and participating in hostage negotiations. Both received standing ovations, with many in the audience sporting black and gold Iowa Hawkeyes jerseys. Haley's aides recently accused DeSantis and his allied super PAC of lying about her record, pointing to fact checks that rated claims by Never Back Down as false. In an October 15 interview with CNN, Haley had questioned why Arab countries weren't doing more to help innocent Palestinians, and she had argued that many Palestinians in Gaza want to be free from this terrorist rule of Hamas. But her campaign underscored that Haley opposes taxpayer dollars for Gaza just like she did when she helped eliminate it at the UN. The money is too easily diverted to Hamas and is not a good use of tax dollars. Arab countries should step up if they want to help Palestinians as much as they claim. Voters eyed both Haley and DeSantis. While DeSantis and his allied super PAC have built a larger ground presence in Iowa, a state Haley is seen as weaker in compared to New Hampshire and South Carolina, voters in the Hawkeye state have taken notice of Haley. Iowa voter Karen Skovgaard, who plans to participate in the Republican caucuses and calls herself a moderate, said she was impressed with Haley's demeanor, her ability to take charge of things. Skovgaard said she trusts her on foreign policy and liked her practical answer on abortion during the first GOP debate, where Haley set herself apart from her rivals by arguing that most federal abortion bans would never pass Congress. Nikki Kemper said her vote was for DeSantis until she attended Haley's town hall in Cedar Rapids Friday afternoon, the first time she saw Haley in person. Hands down, she won it, Kemper said, citing Haley's broader focus on international issues. She really hit on every topic across local and international, and I think DeSantis didn't really cover a lot of the same topics. So I just felt like she was more, well, rounded and really had the experience overseas, as well, to help sell it. Some early state voters who are hoping for a strong Trump alternative are waiting to see who emerges as the most viable candidate of the two. Anyone but Trump, Kirk Hayes replied immediately at a DeSantis event in Algona, Iowa late this summer. But he wasn't sure whether any of the contenders could topple Trump. No one's really come out in front. In a follow-up interview this month, Hayes, 87, said he was still considering both Haley and DeSantis, even though the Florida governor is a little more conservative than I am, Hayes said. But it's not a deal-breaker for me. Wells reported from Cedar Rapids, Iowa. Scott Clement contributed to this report. Sidney Powell was Trump's biggest fighter. Now she's a big threat. Powell, who was angry that Trump didn't act on her counsel, is the government's most prominent asset in its quest to convict him. In the weeks after the 2020 election, a self-assured lawyer with a southern drawl quickly climbed the ranks of the movement trying to keep President Trump in power. She aired outlandish assertions on Fox News and before cameras at the headquarters of the Republican National Committee, filed a battery of lawsuits pressing Trump's case and took part in an Oval Office meeting where the president considered naming her a special prosecutor. Then Sidney Powell fell back down to earth. Trump's team spurned her. federal prosecutors demanded her fundraising records. She was ordered to pay sanctions for filing a frivolous lawsuit in Michigan. The State Bar of Texas lodged a disciplinary complaint against her. 2 companies that make voting software sued her. All that was before prosecutors began filing criminal charges. In August, she appeared as an unindicted co-conspirator in the federal indictment accusing Trump of trying to subvert the election, and, later that month, she was charged alongside him in a Georgia case brought by Atlanta area prosecutors. On Thursday, Powell resolved the Georgia case by pleading guilty to 6 misdemeanor counts of conspiracy to interfere with the performance of election duties. Her plea related to her involvement with a secretive effort to access and copy election software in rural Coffee County, GA in the months after the 2020 election, part of an attempt to prove Democrats might have tampered with the machines. The deal turns Powell into the government's most prominent known asset in its quest to convict Trump, potentially now dangerous to the president she once supported. But it also represents a personal minefield for the 68-year-old lawyer, who is still fundraising based on a promise to sponsor causes that are dear to supporters of the former president, including the legal defense of people accused of breaching the Capitol on January 6, 2021. The plea deal sent shockwaves through circles loyal to those causes. "I'm surprised," said Jonathan Mosley, an attorney who has represented numerous January 6 defendants. "She built a reputation on being a fighter. She wrote a book called License to Lie about government corruption. I just wouldn't have expected her to stop fighting." Powell's attorney, Brian Rafferty, declined to comment. As part of her plea, she was required to write a letter of apology to the people of Georgia, a terse handwritten note on a legal pad that she submitted to prosecutors Thursday that indicated she was sorry for her actions in Coffee County, according to a person familiar with the message who spoke on the condition of anonymity because of the matter's sensitivity. For now, the terms of Powell's plea agreement prohibit her from discussing the case publicly or speaking to others charged. That leaves associates to debate whether she is now a Trump antagonist or remains a loyal foot soldier. After Trump declined to act on some of the most brazen proposals, including naming Powell special counsel and seizing voting machines, she soured on him, according to someone who discussed the matter with her and spoke on the condition of anonymity because of the ongoing criminal cases. "She was disgusted with his unwillingness to take action," said this person, who recalled finding it unusual that she was expressing personal disappointment with someone whose election defeat she continued to try to reverse. But an attorney who once worked for Powell's firm, Sidney Powell PC, rejected the notion that her personal feelings toward Trump would influence her testimony. The idea that she would shade her testimony based upon a personal bias could only be suggested by someone who does not know Sidney well. "Of course, I don't think Trump committed any crime, and so I don't think there is anything to hide," the attorney, Molly McCann Sanders, wrote in an email. Of her one-time boss, the attorney added, "I know her first priority will be to be truthful. I'd like my key and my White House pass." Powell toiled for decades in high-stakes, but low-profile, circumstances, as a federal prosecutor in Texas and Virginia and then a private litigator representing defendants in the Enron financial scandal and other disputes. She gained prominence in 2019 when she took over the defense of Trump's former national security advisor, Michael Flynn, who had pleaded guilty to lying to the FBI. She went to great lengths for her client, writing to then-Attorney General William P. Barr about the matter, and, by her own account, personally briefing Trump on the case. The Justice Department announced plans to drop the case in 2020, and Trump ultimately pardoned Flynn. "I wish I knew," Powell said in a 2021 interview with the Australian Broadcasting Corporation, when asked how she became involved in Trump's post-election legal efforts in 2020. She said she was in the area at the time and working on another matter with Trump's personal attorney, Rudy Giuliani. "The next thing I know I'm smack in the middle of it," she said. "And people are pouring in with offers of help and wanting to investigate and wanting to give us affidavits." One of those people was a Minnesota artist with no apparent expertise in election administration, who wrote to Powell 4 days after the election, acknowledging that her claims were pretty wackadoodle and yet alleging widespread malfeasance by Dominion voting systems, malfeasance implicating the upper echelons of the Democratic Party. Powell aired some of those ideas the next day on Fox News. The November 8, 2020, broadcast was the first in a string of Fox appearances by Powell over the next month, appearances in which she introduced millions of Fox viewers, including the then-president, to fantastical claims of election fraud and burnished her pro-Trump bona fides. On November 13, she teased that she would soon publish voluminous evidence of fraud. "I'm going to release the Kraken," she said, a reference to a mythical sea monster that soon morphed into a viral pro-Trump rallying cry. Less than a week later, she shared the stage with Giuliani at a news conference held at the headquarters of the Republican National Committee. The president primed his supporters for the occasion on Twitter, now known as X, important news conference today by lawyers on a very clear and viable path to victory. Pieces are very nicely falling into place. RNC at 12 p.m. Powell, who was presented by Giuliani as a member of Trump's legal team, alleged a vast conspiracy by foreign forces to switch the outcome of the election. "What we are really dealing with here and uncovering more by the day is the massive influence of communist money through Venezuela, Cuba, and likely China and the interference with our elections here in the United States," she said at the November 19, 2020, news conference. 3 days later, the Trump campaign sought to distance itself from her. Giuliani, in a statement issued by the campaign, said Powell was practicing law on her own. As one campaign official put it at the time, she was too crazy even for the president. Powell pressed ahead with her claims, filing a series of ultimately unsuccessful lawsuits, which came to be known as the Kraken cases, seeking to reverse the outcome of the election in numerous states. And a month later, Powell gained access to the White House and an audience with Trump. Late on a Friday night a week before Christmas, Powell and a handful of others, including Flynn, urged the president to take extreme measures to unearth evidence of fraud and reverse his defeat, according to the testimony of people present. As the December 18, 2020, meeting unfolded, first in the Oval Office and then in the White House residence, an aide described it in a text message as unhinged. During the hours-long discussion, people present later said, Trump weighed seizing voting machines from key counties, deploying the National Guard to potentially rerun the election and appointing Powell as a special counsel to investigate the election. There was a proposal made by Sidney to become special counsel. Bernard Kerik, a former New York Police Department commissioner and close ally of Giuliani, said in a deposition taken by the House Select Committee investigating the January 6 attack on the Capitol. Powell, in a deposition with the same panel, said the president asked me to be special counsel to address the election issues and to collect evidence. But the plan sputtered, she said. The next morning, she placed a call to Mark Meadows, the White House chief of staff, to say, "Hey, I'd like my key and my White House pass," as she recalled. And his response was, "Well, that's just not going to happen. No reasonable person." The reckoning for Powell began before the year was out. In December 2020, a former Dominion employee sued her for defamation in Colorado. He argued that she, Trump and others ruined his reputation by linking him to false claims the election was stolen. The case is still pending. The next month, Dominion itself sued her for defamation, asking for $1.3 billion in damages. No evidence has ever emerged that its machines were used to swing the election. Another company that makes voting software, Smartmatic, followed suit in April 2021. A New York judge later dismissed the claims against her, but the company has a separate federal case, which is still pending. Responding to Dominion's claims that spring, Powell's attorneys contended that her statements could not be proved true or false. No reasonable person would conclude that the statements were truly statements of fact, they wrote. Their argument was that she was merely asserting her opinions and legal theories, not that her claims were necessarily wrong. Still, Trump erupted at the defense, and she quickly fell out of favor with him, said people familiar with the matter, who said she has not been a presence in his inner circle for several years. Initially, he expressed appreciation that Powell was fighting for him while others were giving up. But her theories were scorned by other lawyers, and Trump ultimately conceded that Powell was too conspiratorial even for him. In recent months, Trump has told others that Powell was not his lawyer, while maintaining that he liked her at the time, according to an advisor. Trump's lawyers believe they can undermine her as a credible witness because she has cast doubt on the veracity of her own statements, the advisor said. Powell's troubles mounted later in 2021, when the U.S. Attorney's Office for the District of Columbia sought communications and other records related to fundraising and accounting by a number of groups started by Powell, including Defending the Republic, a Texas-based organization claiming 501(c) for nonprofit status, and a PAC by the same name, according to documents reviewed by the Washington Post. An attorney for Powell said at the time that, "We have always known the more effective we are, the more the false attacks will intensify. Defending the Republic has and will continue to fight for #We the people who make this country work." The nonprofit group raised $16.4 million in the year following the 2020 election, according to tax filings. According to its website, Defending the Republic's causes include election fraud, fighting lawfare, exposing government corruption, fighting mandates, defending January 6 heirs, and Freedom of Information Act litigation. The group has helped cover legal expenses for numerous people prosecuted for their alleged involvement in the pro-Trump riot at the Capitol, according to defense attorneys involved in these cases. Mosley, the attorney who has represented January 6 defendants, said the money hasn't always come through as promised. One of his paralegals still needs to be paid, he said, and another attorney has complained to him of not receiving payments for some time. "I think Sydney's funding had to take care of her and some of her legal battles," said Mosley, who was disbarred last year in Virginia for violating a range of professional rules. At the end of 2021, a federal judge in Michigan ordered Powell and others involved in the November 2020 lawsuit that challenged the election results in that state to pay about $175,000 in legal fees to the state of Michigan and the city of Detroit. The judge, Linda V. Parker, called the fees an appropriate sanction, needed to deter plaintiffs' counsel and others from engaging in similar misconduct in the future. An attorney for Powell, Howard Kleinhendler, criticized the decision and vowed to appeal, but a federal appeals court panel upheld the sanctions against her. Last year, a disciplinary commission within the Texas bar sued Powell for professional misconduct. A state judge tossed the complaint, prompting the commission to appeal. Guilty. Jury selection in Powell's trial in Fulton County had been set to begin this week. Conviction on 7 felony counts, including violation of Georgia's Anti-Racketeering Act and conspiracy to commit election fraud, could have been rock bottom for the embattled lawyer. Her deal to plead guilty only to misdemeanors means she will avoid jail time. In addition to 6 years of probation, she agreed to pay a $6,000 fine and $2,700 in restitution to the state of Georgia. The deal may also help preserve Powell's ability to practice law because it involved prosecutors spelling out that her crimes did not involve moral turpitude, language she could use to fend off the complaint in Texas. And because Powell has no prior felonies, successful completion of the terms of her sentence will allow her under Georgia law to erase the convictions from her permanent record. The deal means better consequences for her, Mosley said, but it puts her standing in the pro-Trump movement in doubt. "It's going to be hard to rally the troops after this," he said. Instead of furnishing evidence of election interference by the Chinese or Venezuelans, she is admitting to having engaged in it herself. Guilty, she intoned in a downtown Atlanta courtroom, when asked by a prosecutor how she pleaded to the charges. Powell was the second of the former president's 18 co-defendants to plead guilty and agree to testify. Bail bondsman Scott Hall pleaded guilty in September. Another defendant, Kenneth Casebro, pleaded guilty on Friday to a single felony count of conspiring to file false documents, a charge related to his role in organizing GOP slates of electors in 7 states won by Joe Biden to cast votes for Trump anyway. Powell has now agreed to testify against the remaining defendants in the case, including Trump. It's not known what precisely prosecutors hope to learn from Powell and when they might call her as a witness. Fulton County Assistant District Attorney Daisha Young read aloud in court the facts prosecutors would have presented against Powell at trial, describing how Powell entered into a conspiracy with several co-defendants in the case. The purpose of the conspiracy, Young said, was to unlawfully access election machines in Coffee County. At the center of the conspiracy, Young argued, was Powell's move to retain Sullivan Strickler, an Atlanta-based cyberforensics firm, an effort that was first publicly revealed by the Post. Her testimony could reveal whether others in Trump's orbit were involved with or aware of the scheme. There are some clues about ways Powell may be able to link members of Trump's inner circle to the far-fetched effort. In a December 2020 email, which was read aloud during a deposition taken by the House Select Committee investigating the January 6 attack, Powell seems to have kept Meadows, another defendant in the Georgia case, apprised of efforts to access voting software in various states. Georgia Machine Access, promised in meeting Friday night, part of the email read. A lawyer for Meadows did not respond to a request for comment. Powell is now limited in what she can say publicly about the Georgia case. But her nonprofit, Defending the Republic, asked followers for forbearance in a Friday newsletter distributed via the Substack platform. We at Defending the Republic appreciate your patience, support, and understanding of Sydney's decision regarding the Georgia case. Now that this is behind us, we can focus on our mission, the newsletter vowed. Emma Brown contributed to this report. Special counsel urges judge to deny Trump's January 6 claim of immunity. The defendant is not above the law, prosecutors say in opposing former president's bid to toss out federal 2020 election subversion prosecution. U.S. prosecutors urged a federal judge Thursday to reject former President Donald Trump's claim of absolute immunity from criminal prosecution for actions he took in office, saying that he is not above the law and that his indictment for allegedly conspiring to block the results of the 2020 election should not be dismissed. No court has ever alluded to the existence of absolute criminal immunity for former presidents, Assistant Special Counsel James I. Pierce wrote in a 54-page filing. The filing argued that legal principles, historical evidence, and sound policy reasons establish that once former presidents leave office, they are subject to federal criminal prosecution like more than 330 million other Americans, including members of Congress, federal judges, and everyday citizens. Trump lawyers John Lauro and Todd Blanche moved to toss out his indictment October 5, claiming that the Constitution, Supreme Court, and hundreds of years of history and tradition made clear that a president's motivations were not for prosecutors or courts to decide, but that where the president's actions are within the ambit of his office, he is absolutely immune from prosecution. In a dense response with 8 pages of legal citations, prosecutors argued that that claim turned the law on its head, just as they said it drew a false parallel between Trump's fraudulent efforts to overturn the results of an election that he lost and the likes of Abraham Lincoln's Gettysburg Address and George Washington's farewell address, adding dryly, "These things are not alike." Instead, they said the Constitution's separation of powers principle should apply to presidents like it does to judges, who enjoy absolute immunity from civil damages liability for certain conduct in office, but remain subject to criminal laws. The indictment alleges that the defendant acted deceitfully or corruptly to secure a personal benefit to himself as a presidential candidate, not to carry out constitutional obligations entrusted to the presidency, prosecutors said. Immunity should not foreclose the government from shouldering the burden to prove those demanding standards beyond a reasonable doubt at trial. Trump has pleaded not guilty to a 4-count indictment accusing him of a criminal conspiracy to remain in power, obstruct Congress's lawful certification of Joe Biden's 2020 election victory, and deprive Americans of their civil right to have their votes counted. Trump and his lawyers have accused the Biden administration of targeting Biden's chief political rival and frontrunner for the 2024 GOP presidential nomination, maintaining that Trump acted within the bounds of the presidency to seek to overturn the 2020 results. In seeking to toss his case, they also argued that just as courts have barred lawsuits against U.S. presidents for actions taken within the outer perimeter of their official duties, the same principle should apply to criminal prosecution. They suggested the Supreme Court should take up the question, a legal battle that if joined could postpone his scheduled March 4 trial before U.S. District Judge Tanya S. Chutkan that Trump has sought to push back to after next November's election. No court has addressed whether such presidential immunity includes immunity from criminal prosecution for the president's official act, the lawyers wrote, arguing that Congress's failed impeachment of Trump was the proper venue to decide Trump's guilt or innocence. Prosecutors said Trump's claim directly conflicts with the Constitution, which explicitly provides that presidents impeached and removed from office can be criminally prosecuted for the same conduct. During his impeachment trial, Trump argued as much, saying he could be prosecuted later if the Senate acquitted him, which it did, special counsel Jack Smith's team wrote. Trump would turn the impeachment judgment clause on its head and have the court read it as a sweeping grant of immunity that forbids criminal prosecution in the absence of a Senate conviction, which, among other things, would effectively preclude any form of accountability for a president who commits crimes at the end of his term of office, prosecutors wrote. To the contrary, they argued that the clause was meant to limit Congress's power to removing and disqualifying presidents from office, not to preclude the prosecution of those who escaped removal. They added that temporary legal shield enjoyed by presidents while in office and the ongoing protection they retain from civil liability for official acts once they leave are both premised on the backstop of the availability of accountability for criminal conduct, citing a range of sources including Founding Father Alexander Hamilton's writings in the Federalist Papers and President Gerald Ford's full pardon of his predecessor Richard M. Nixon for any offenses committed during his presidency. Finding otherwise would be startling, prosecutors wrote, freeing from the threat of prosecution a president who accepts a bribe in exchange for a lavish contract for a family member, instructs the FBI director to plant evidence on a political enemy, orders the National Guard to murder his critics, or sells nuclear secrets to a foreign adversary. A president could act with particular impunity in a second term to benefit himself, endanger the republic, or both, a perverse outcome when Trump is accused of a criminal conspiracy to remain in office, Pierce wrote. Even accepting Trump's argument, prosecutors said his alleged crimes did not occur within his official duties, but were undertaken as a candidate abusing the public trust. The indictment casts Trump as a habitual liar and sore loser who spewed false claims about purported voter fraud in the 2020 election and then used deceit and lies to try to get state, local and federal officials to change the results to the point of violence in the January 6, 2021, attack on the Capitol. The case is one of 4 felony prosecutions Trump faces, including a state trial in Georgia that involves similar allegations of trying to obstruct the state's election results, a federal indictment in Florida over Trump's alleged retention and mishandling of classified documents and obstruction after leaving the White House, and a New York State business fraud prosecution accusing Trump of covering up hush money payments made during the 2016 election campaign.